Morning, everyone. Hopefully you can hear us and see us okay. If there are any issues, please just pop a note in the chat section. But hopefully we're good to go and everyone can hear. So I'm welcome this morning by Alyssa. So thank you, Alyssa, for joining us again.
Morning, morning, everyone.
Morning. Really looking forward to obviously hearing Alyssa's topics today, but especially because there's a very hot topic in there. Actually, we were briefly just talking a few moments ago with regards to the navigating the gender identity in the workplace. So, of course, it can be quite a minefield for employers with all the right intentions to sort of navigate. So, really looking forward to listening to that. And it kind of ties in really with sort of the increased demand that we're finding at JVP as well with regards to support being asked for around writing job adverts and ensuring that inclusive language is being used within them. So I'm not surprised that Alyssa's chosen to put that on the agenda today. I'd say certainly a hot topic, and hopefully there's going to be lots of really good tips and advice as usual to take away. I turned on the news this morning and heard more stories about P&O. So obviously the ship floating away was yesterday, and the new agency temps obviously now speaking to the union reps, some of them wanting to leave and they're sort of tied in. So no doubt, Alyssa talking through what you have got to speak through with regards to P&O later will be very welcomed, Alyssa, because I'm sure we'd all want to learn those lessons to avoid those for any situations we could find ourselves in. It seems quite an extreme case, doesn't it?
It's the story that keeps on giving at the moment. It's when I read the news yesterday about them floating offshore, it's staff. It's a staff issue. We'll cover it in session, don't worry.
Absolutely. And of course, none of us can hide from the fact with the cost of living and business costs obviously rising alongside that at quite a pace now. I'm sure that the insights that you're going to provide, Alyssa, on the national insurance increases and the real impact really that they're having on businesses will be quite an interesting one too. So now I know that you've got loads to share today, Alyssa, so I'm keeping this really, really brief now so you can get straight stuck in, because there's going to be a lot of really useful tips there as we go through. Now, if anybody's got any questions, if you want to pop them in the chat section as we go, Alyssa, I'm sure we'll do our best to answer them through the session. If not, then certainly towards the end, we usually have sort of 5-10 minutes or so where we might be able to cover them off then. So that's everything from me, and over to you, Alyssa. Thank you.
Thanks very much, Kath. So I've seen quite a few names that we've seen before, but for those of you who haven't met me before, my name's Alyssa Thursfield. I'm Head of Employment at Gamlen's Law and also the Managing Director of HR Anchor, a HR employment support company. As Kath said, we've got a lot to get through today. There's quite a lot of content, hopefully lots of lessons that we're all going to learn and take away from this. And obviously we've also got the big topic at the end that we're going to try and sort of tiptoe round to some extent and see what we can pull out of some of the active cases that are going on at the moment. So we're going to cover P&O ferries, lessons learned, illegal implications. The lessons being learned are still coming out of this situation, as we've seen in the press yesterday and this morning. National insurance increases and their impact. We're also going to look at things like cost of living increase and minimum wage increases. And then, as I've said, navigating gender identity in the workplace. So kicking straight off with P&O, could PR get any worse for a company than it has done for P&O? They've actually admitted that they've broken the law, which is highly unusual. You often, in situations such as this, get very vague statements from senior management saying, it's unfortunate the impact on people, but they feel they've done everything properly. No, they've actually come out and very brazenly said, no, we have broken the law, but we had very good reasons supposedly for doing so. So what actually happened then? So for anybody who's been perhaps living under a stone and hasn't noticed what's gone on, 800 workers were dismissed without process or warning. There was a pre-recorded Zoom call that set out that the business was no longer financially viable with its current operating model and that it needed extreme action in order to be able to continue to trade. The people on the call were informed that they were redundant with immediate effect and that settlement agreements would be offered and they would be paid an enhanced payment provided they complied with the terms of the settlement agreement. So there were no individual meetings and no sort of real opportunity to negotiate those settlement agreements. It was take it or leave it. You'll only get your enhanced payment, which we don't know exactly how they were structured, or that would be it. So the bosses have admitted that they broke the law. They stated that because the cost of operating the business whilst consulting, so if they'd gone through that consultation process, the cost of operating the business would have been 309 million. Now, I don't really like this statement very much because if you don't read it carefully when you're reading the press and you're reading their statements, it almost suggests that the cost of consultation would have been 309 million. It's not. When you sort of unpick it a bit, what they're saying is the cost of continuing to operate during that consultation period was 309 million, which I presume is their normal operating costs. They claim that the business was losing over £100 million a year and that the redundancy has cost the business 36.5 million. However, since those redundancies, every ship has been required to pass safety inspections and some are still not sailing. The reason for this that has been given is that because the normal crew have been removed and they've been replaced with agency staff, that because of the training that's going to be required for those agency staff, that's the safety checks that they're having to pass. They're not suggesting that these ships aren't mechanically viable. Now, as we've seen in the press, one of those ships that has been released was then found drifting in the Irish Sea yesterday, and the AIS message that went out over the waves said that the ship was no longer under command. So for any of you that have got maritime backgrounds or have got a bit of a seafaring background, one, that's a bit of a concerning message, but two, for a ship of that size that's carrying cargo and passengers to not be under command in a busy operating channel on the Irish Sea, that is extremely serious indeed. 3 RNLI lifeboats were launched to it, as well as Coast Guard helicopters, and it was taken under tow and brought back into port. Now, P&O are saying that it was a mechanical issue. However, we're seeing leaks coming out from the staff to say that essentially this was strike action, that they were no longer operating the ship. We're also seeing coming out of the press agency staff saying that they wish to be released from their contracts. We're seeing that there's been attempts to potentially renegotiate what's being paid to those agency staff to make the wages even lower. And P&O have come out very strong on this and said they're tied into their contracts. If they leave early, they will not be paid. Those agency staff, as we are aware, are not being paid the national minimum wage as set in the UK. They are being paid under another loophole, essentially, because they're international agency workers and under various maritime regulations, which we don't need to get down into the nitty-gritty of that. However, the key point being that there is a business operating in the UK between UK sites as well, where they're employing people who are engaging agency staff who are not being paid the national minimum wage. So P&O reckon that they're currently losing £1 million a day by not operating all of their ships. And we've also still got the situation where we don't know if all the staff have actually accepted their settlement agreements, so they could be facing significant legal action as well in respect of those terminations. So when they say that the business was losing over £100 million a year and this was necessary to put a dent into that and to make some savings, when we look at the fact that they're losing £1 million a day, that they've potentially got strike action on their hands, that they've upset the unions and there's still action going on, their PR is in an absolute mess. How much have they actually saved by undertaking this exercise in the way that they did? Now, P&O have said that the measures that they took were necessary to save the business. So, a bit of a poll this morning just to get our brains working and engage with the topic. What they say is that the loss of these 800 jobs saved over 1,000 other people's jobs. So, in those circumstances, do you believe that the ends that they employed justified their means? Was it justifiable to terminate the contracts of 800 people immediately to save over 1,000 jobs? So I'm going to open the poll now, nice and quick if we can. Where do you sit with this one? And we don't have an on the fence, I'm not sure answer, it's yes or no. Did the ends justify the means? Oh, we're having a bit of a think. Anybody not sure? They are anonymous, so don't worry, it's not going to put your name to anything if you're not sure where you want to sit on this.
I think the poll may have only just appeared in the chat now, actually, so hopefully everyone can see it now there in the chat section.
So, okay. No. There we go, they're coming up now. Okay, Okay, so it's coming up on the chat but not on the poll. But okay, well, we've got an idea. The majority of people are saying no, the ends did not justify the means, which is interesting. So have they really saved any money? So what I touched on here already. So they've got, what we think is it's unlikely that the action that they've taken and the way that they have done it has actually saved them any cash. They've got ships that are confined to port. Like I said, we're not sure if all 800 will have taken the settlement agreements. With balance of probabilities, it's probably a low chance that they've all taken them. And there's also a question of whether those settlement agreements are going to meet the legislative criteria. There's no opportunity for negotiation. The outcome's already been predetermined. You know, that their employments have already ended. If I were advising any of those people, the chances are that I would be saying, don't take it. There's a number of claims potentially open to these people because of the way that this has been done. P&O have also been hit with port fines, and they've had to refund passengers for the sailings that they haven't been able to put to sea. As I've already said, £1 million a day operating loss. There's potentially criminal sanctions that are going to hit the business as well, and those are unlimited. There's the loss of commercial contracts that we've also seen in the press, so in terms of haulage providers who are cutting ties with P&O, and also the management time of dealing with the fallout. So the message here really is, whilst it might feel easy to skip steps of a process, or perhaps, you know, that a process is there to tie you in red tape, here is a prime example of a company that thought by skipping this period that actually they could justify the ends because they were going to save money and save jobs. The reality is, because of the state of the business at the moment and how difficult they're finding it to operate, it's probably going to put even more jobs at risk. What's interesting as well is that we've been unable to find any published figures that show how much the business was going to save by employing agency staff. So they made a big song and dance about how by using these foreign agency workers, they were going to be saving lots of money. We have not found any credible figures that the company has put their name to that shows how much money they're going to save. So what should have happened then? What should they have done? So with over 20 people being made redundant in a 90-day period, that triggers what's called collective consultation, and therefore there are strict rules that have to be followed. So just for clarity, for anyone who's not familiar with the terms that I'm using here, if there's fewer than 20 people being made redundant, then there's no collective consultation and no strict procedure. But the action that you take must still be fair and reasonable, and we always advise that a procedure is followed because otherwise the dismissal is likely to be procedurally unfair. So when we're talking about these over 20 people being made redundant, there's often lots of legal arguments over whether they've actually reached the 20 figure. I'm not talking about the P&O example because it's very clear because there's so many people being employed, but there was a large Woolworths case when Woolworths was closing over whether all of the stores should be amalgamated together, so then you're looking at hundreds, potentially thousands of people being made redundant, or whether it was on a store-by-store basis, which would potentially mean that in most cases relating to individual stores, there wasn't the requirement for collective consultation. So the requirement is 20 people being made redundant at a single establishment. And what came out of Woolworths and also the Ethel Austin case was that this is generally taken to mean a local unit. So for any local unit where more than 20 people are being made redundant in a 90-day period, so you can't make 10 people redundant one month, 10 people the next month, and 10 people the month afterwards, you would then have triggered collective consultation. They don't all have to be at once. So what is collective consultation? Now, this is laid down in law in terms of the process that has to be followed. So the Redundancy Payment Service, the RPS, needs to be notified before consultation starts. Now, where more than 100 staff are being made redundant, that must be done 45 days before the start of the consultation. They have to consult with trade union representatives or elected employee representatives or staff directly if there are no representatives. Now, you may wonder what on earth is an employee representative. Well, that isn't a lawyer. The staff should be permitted the time to hold elections, and they can elect an employee who is going to be their voice, essentially their representative during this consultation. If there isn't a trade union, they can elect employee reps if there is a trade union as well. So that means that you've got figureheads that you can then consult with if you're the employer, who will then cascade information down to the remaining staff. The business must provide information to the representatives or the staff about planned redundancies, giving them time to consider what's being given to them. They have to respond to requests for further information. They have to give communication that sets out the dates of what's being planned. And then finally, they have to issue the notices that gives the date of redundancy and how much money the staff are going to get. Now, for over 100 staff, there's a minimum consultation period of 45 days. So with P&O, this is where we get that when they were talking about the 3-month period that they will be operating through. This will be the 45 days before consultation starts for the notification to the RPS, and then the minimum 45 days as well then for the consultation period itself. So the consultation itself must provide the reason for the redundancies, the numbers and categories of employees that are involved, the numbers of employees in each category, how you plan to select employees for redundancy, how the redundancies will be carried out, and how redundancy payments will be worked out. So it's not enough for consultation just to say the business is in trouble, we need to make redundancies, and we're going to have a bit of a chat with you about it. It's very specific, the information that needs to be provided to trade union reps, employee reps, or the employees themselves, so that it can be a real engaging process and that they can have some actual input into the process. Never mind the legal situation, morally as well, by having this consultation period and the time before the hammer falls, it gives employees time to prepare and become aware that their job potentially could be at risk. It gives them a chance to find more work. So the P&O staff found out on one morning that their jobs were ending that very day. To go home then and suddenly try and find work is going to be very difficult. It's very stressful. You're still trying to process the fact that your employment's come to an end. Morally, by giving this window of consultation, people can also start to put feelers out to look for other work to mitigate the impact of that redundancy on them. Gives them time to claim on mortgage insurance cover. So anyone who has insured their mortgage payments has got time to ring their bank, see if they're covered, and make arrangements for those payments so that their mortgage can be paid if they've got that kind of cover. Also gives them time to plan, so perhaps avoiding large purchases or holidays if they know that potentially their employment's at risk. And it also shows employees that they're not just a number. They're not just numbers at the bottom of a spreadsheet or a cost to be cut. It's showing that their opinion matters and that we're recognising the personal impact that these processes have on them. So from a moral stance, it's absolutely abhorrent what P&O have done. They've shown absolutely no regard for the impact that this is going to have on 800 families, and the fact that 800 people were suddenly cut adrift with very little time to prepare for what is an enormous impact on somebody's life. So when we're engaging in this sort of process, it's very easy to get wrapped up in, well, we have to do this because it's going to save jobs. We have to do this to keep the business viable. We also have a moral obligation to staff members to make sure that we do this properly and we give it the time that is due to allow employees to have the time to prepare for the fact that their life is about to change. So what legal claims can P&O be facing? Well, failure to consult up to 90 days pay per employee. For unfair dismissal, it would be compensation for loss of earnings if they're unable to find work. So the basic award that you normally see for unfair dismissal, they wouldn't get because they'll have had their redundancy payments. In terms of the criminal offence, that's a failure to notify the Secretary of State. The fine is actually unlimited. The view that they could potentially take on it would be that the money that has been saved by not undertaking consultation has been gained by criminal means. So in one fell swoop, the Secretary of State could knock out that supposed gain that P&O believe they have made by not engaging in this process, and not to mention the fact that then there could be criminal records that are handed out. Now, also, there could be potentially TUPE-related claims. So, for those of you who have been involved in TUPE processes before and sort of have that little shudder like I do because I hate TUPE, where you are outsourcing an element of the business, so in this case, what they've done is gone, well, actually, the roles are still mostly there, but we want to use cheaper labour. We're going to outsource it to an agency. That's a service provision change, which would technically trigger TUPE. So the staffing's been outsourced, and any dismissals, therefore, could potentially be automatically unfair under the TUPE regulations, and that would give a protective award of 13 weeks' pay for each staff member that's where their role has essentially transferred to an outsourced company or entity. So that's something also to bear in mind, that the money that they have supposedly saved and how unviable the business was, the reality is they've perhaps taken 2 steps forward and about 10 steps backwards by doing what they have done. So moving on swiftly, we're going to go on to increases in national insurance and national living wage. So we've seen increases across the board for 2022. The table on the right-hand side of the screen will show you the national minimum wage increases. So the top table, we've got the 2021 rates, and the bottom table, the 2022 rates. You'll also see that the age for national living wage has come down as well. So from 25 to 23, and we've gone up from £8.91 to £9.50. In addition to the national minimum wage increases, we've also got national insurance contribution increases for employers and employees at a rate of 1.25%. Now, 1.25% might not seem a lot when you look at it in isolation. However, when you factor in the fact that we've got national insurance increases, we've got national minimum wage increases, and increases to cost of living, which also translates to the increase into the cost of running a business. Your electricity costs are going up, your fuel costs are going up. It's suddenly becoming very expensive to employ staff. So we're going to break down some further figures as well. So in addition to national minimum wage, statutory sick pay has gone up from £96.35 to £99.35 a week. Now, these might appear quite small on your screen. We do have all this in one handout that shows the changes to payments and what the current payment rates are. Maternity, paternity share, parental leave payments have gone up, and also compensation payments, awards, and how you calculate a week's pay for things like redundancy have also gone up. So they're in the bottom right-hand corner. And the Vento bans have also gone up as well, so for discrimination-related complaints. This is a really handy handout. So like I say, we can circulate this after the session if that's useful, but just be mindful, it's not just the minimum wage and national insurance that's gone up, it's all the legislative payments as well. So in terms of then the cost of actually employing staff, we've estimated for a staff member who is on the national living wage, the increase is £25.27 per employee per week. Now look, take these with a pinch of salt. I'm a lawyer, not a mathematician or accountant. However, this is sort of on a very basic level what we would estimate those costs to be. That translates at an increase of £1,314 per year extra per employee when you factor in pension contributions and the national insurance increases as well. So if you were to have 15 staff who are being paid at the minimum wage, that is an extra £20,000 a year that your business needs to find to employ those people. You also think that the cost of electricity has supposedly risen 54%. Average small businesses spend about £3,000 a year on power. The bills are starting to climb, and it is increasingly difficult to engage staff. But what if you say, well, I pay my staff more than national minimum wage, I'm fine, I'm insulated against this? Well, unfortunately, you're not. Because individuals are seeing an increase in their own cost of living, so it's more expensive to fill the car, childcare has become more expensive, the cost of heating and powering their homes has become more expensive. We're likely to see an increase in things like car allowance requests, so people can try and mitigate the cost of having a family car, more flexible working requests, expense submissions, so people are going to be more on it, we would suggest, and be a bit more proactive in terms of pushing the boundaries of what they can and can't claim. Perhaps tech requests, so asking for laptops and mobile phones. Working from home or wanting to return to the office. We think actually we're going to kind of see this going both ways. So people who see their home office bills going up because they're sat at home, they've got heating on, they're using electricity, suddenly think, actually, I don't need to be doing this, I can be using somebody else's electricity, I want to go into work. For those who are in the office, and things like the cost of childcare has gone up, and the cost of commuting has gone up, they're likely to be wanting to go and work from home. And also we're likely to get more pay rise questions as well, so people who are wanting to again mitigate the impact of the cost of living by asking for an increased pay. So in terms of how we can assist employees, have a think about what other things you can do outside of direct financial assistance. So does your company have any links with perhaps mortgage or financial advisors? Is there any other advice that you can give people about dealing with the cost of living in terms of smart meters, or you can get these little gadgets that tell you to turn lights off in your house and things like that. So have a think about what else that you can offer in terms of assistance to employees and advice to employees to help them mitigate these costs of living. If a flexible working request is put in, then do remember that those have to be dealt with properly. So a bit of a reminder about that process. You can't just say no. You can't just say, look, we're not taking any requests at the moment, or it's not the right time for the business. If a formal request is put in, we need to deal with it under a procedure. So ask for the request to be put in writing so it's clear what they're actually asking for. Make sure you hold a meeting to discuss that request, and don't use it as an opportunity to browbeat them about how difficult things are for the business and don't they know how lucky they are to have a job. That is the wrong approach. This should be a meeting to discuss why it's right for the staff member, how it can work for the team, and how it can work for the business. Or if you think that there's going to be an impact on client delivery or an impact on the team, have those discussions with them so that you can draw out information that perhaps they have already thought about. So how they might perhaps mitigate things like that they might be isolated from the team or might not be as engaged in team meetings. What ideas have they got, and how are they planning to mitigate those? When you make a decision, make sure it's issued in writing, and also give them the right to appeal if you're not finding in their favour and you're not going to issue the request that they've specifically asked for. Now, remember as well, when you are making a decision and when you're issuing that to them, if it's a case that you can't actually accommodate what it is that you're asking for, but you think that there's actually something else that you can offer, make sure that you do put that in the letter as well and say, well, look, we're sorry we can't accommodate specifically what it is that you've asked for, and give your reasons. But look, we've had to think about it and we think that actually this could work. Would you like to go away and have a think about that as well? Remember as well, these have to be dealt with promptly within 3 months, the legislation tells us. So this isn't something that we should be dragging on for weeks and weeks and weeks. Do make sure that you deal with these properly and that you don't allow this to become something that drags on. So if you are going to refuse, remember, again, there are limited legal reasons why you can refuse a flexible working request. Those being plan structure or change to the business, the burden of additional costs, where quality or standards are going to suffer. Now, if you're going to rely on that one, you make sure that you can quantify it and that you can actually show what it is that you mean, and you're not just using that as our standards are going to suffer. Well, how? What is it that you expect is going to happen? That you won't be able to recruit additional staff, perhaps. So if somebody wants a very odd portion of the day off or wants a very unusual working pattern that's going to create a job share, if it's impossible to fill those slots, that might be a reason why you can refuse it. If you think performance is going to suffer, again, quantify it. If this is a staff member who's had poor appraisals, perhaps struggles with either development or is struggling with deadlines, and you feel that they need more close management, that their performance, and you think that actually this means things are going to take a turn for the worse, make sure that that discussion is had without overly criticising that employee or making them feel like they're being micromanaged, but equally be honest and fair. If you can't, apologies for the typo there, can't reorganise work among existing staff, but there's a struggle to meet customer demand, perhaps because of the times of day that an employee wants to work, or a lack of work during proposed periods. You should not be giving any reasons for refusal outside of those statutory reasons, otherwise you're going to be getting into hot water in respect of that flexible working request, and you could potentially be handing the employee a legal claim. So hopefully that's just a reminder on those. We've touched on flexible working on these sessions before, but again, because of the issues that we've flagged in terms of cost of living and the rises of the cost of employing staff members, we do think we're going to see an increase in these sorts of requests as well. So moving on to the big one, gender identity in the workplace. Now, hardly a day goes by when we are not seeing issues surrounding gender identity in the press. It's been a long time since a topic was so simultaneously difficult to navigate as well as being fraught with legal risk. You are often seeing that people are worried about speaking about the topic, not necessarily speaking positively or negatively, but actually a fear of just generally speaking about it because of risk of being cancelled, sued, publicly named or shamed, trolled. It can have an impact on staff members for businesses that either speak out about the issue or perhaps make a wrong decision about the issue. It can have an impact on morale. In terms of staff speaking out about it, can create disputes between staff members who feel very strongly about the topic, and also people who feel that they can no longer speak freely about something and they are in effect silenced because it is a difficult topic and it's a topic that's very easy to offend people when you're talking about it. And what this often comes down to is terminology. People either not being up to date with the terminology that should be used, and this is a subject that moves very quickly. There's lots of new terminology or terminology that perhaps we don't come across day to day, and it's difficult to know what words to use or how it is acceptable to talk about this topic without offending somebody. So what is it that is causing the fear then? So there's the furor surrounding labelling someone as a man or a woman, or making statements about what only a man or a woman can do. So we've seen the row that surrounded J.K. Rowling in terms of some of the comments that she has made. There's misunderstanding around labels and the sensitivity around misuse and whether you should actually be labelling anybody as anything anyway. The fear, as I said, often stems from a lack of understanding sometimes, or a lack of understanding around what terms can be used to engage either in a debate or discussion about topic. And also we've got the strength of the woke and the cancel culture voice currently. It's got the ability to end careers and it has the ability to make people feel that they are silenced. Now, from a personal perspective, I do feel like any topic should be able to be discussed provided you afford everybody respect and a fair and an open forum in which to discuss. I don't think we should intentionally try and offend people, but I think that the culture that we're operating in at the moment is that there are pockets of society that are easily offended and where there is this very strong voice about only saying things that are absolutely acceptable. I am an advocate of free speech, again, provided we're within those parameters of respecting those and treating people equally around us. So I am going to try and take that stance as I go through this. Again, if I do offend anybody, I am very sorry. So it's a difficult topic to navigate, and I'm going to try and talk about it as respectfully and as inclusively as I possibly can. So when we have a look at the headlines, we've had tax expert Maya Forestater, who was fired for saying that trans women are not women. We've had Bristol University in the headlines, so the poster that you see on the top left-hand corner of the screen saying, do you feel like someone is using the wrong bathroom and what you should and shouldn't do if you see someone who you think shouldn't be in a certain facility? We've seen the Leela debate, so female swimmers who were beaten by a transgender athlete who staged a podium protest. So you can see that in the central image. The swimmers who came second and third joined together on one podium who were protesting against Leela, the swimmer who's transitioned from being male to female and wants to compete competitively in the female category. Emily Bridges, so the transgender cyclist who has been told she won't be able to race in women's national Omnium events, against this male who has transitioned to being a woman. And Bristol University, which has been labelled as the wokest university. So we had a lecturer there who says that she faced a year's worth of a hate campaign after making comments about things that she states only biological women can do. So as I said, it's rarely out of the press. It's something that is generating a lot of debate and a lot of discussion and nervousness around those debates as well. So, quick poll before we go any further. Would you feel comfortable addressing queries around gender identity in the workplace? So if a staff member came to discuss the company's approach to gender identity, or if you had a staff member who perhaps wanted to discuss their own issues with their own identity, would you feel comfortable addressing that, or would you feel that it's something that's fraught with risk? So again, really quickly, how would you feel about talking about this sort of topic? just wait for those to come through now. I mean, personally, at the moment, I probably would, purely because I'm doing quite a lot of reading and learning around the topic. So, seeing some fluctuation, yeses between sort of 50 and 60%, no's at 44%. So, you know, it's quite split. And given the people who we've got on the chat, you know, we're probably all regularly talking to employees and businesses about issues, but it's not an overly surprising result. So yes, hovering around the mid to high 50s, and no in the 40s. Okay, well, hopefully we can help make people feel a bit more confident when talking about the issue. And for those of you who said no, perhaps give you some things to have a think about, to give you that confidence, perhaps to have these discussions if needed. So, you know, I couldn't even write a headline for this slide. That's the next slide. Could I put what is gender identity? Then I'm labelling it as a specific issue, which again, there's some pockets of society that don't even like that. Or how to deal with gender identity. Well, should we really be dealing with anything? This is a matter of equality and how, you know, we operate on an inclusive basis with staff members. Such is the sensitivity of this issue that I had to have a chat with my managing director to make sure I don't get fired for presenting this. You know, if somebody were to raise a complaint about perhaps something that I say, and I've run him through the issues that I will be touching on in this presentation. So even for myself, as someone who does a lot of presenting, I do quite a lot of speaking publicly, and I do read very widely around these subjects, I still had an element of nervousness about presenting something like this publicly. So terminology, this is where there's quite a lot of confusion. People aren't always entirely sure what terms mean, or, you know, what term they should be using when. However, do we even need terminology? At the end of the day, aren't we just employing people? We're not employing necessarily women, men, agenders, and digijones, bigender, gender fluids, non-binary, polygender, transgender, trans, and there is a lot. The list is huge. But ultimately, at the end of the day, we are employing people, and we should be managing people and dealing with people in an inclusive, fair, and equal way. So in some respects, there's an argument to say we don't even need terminology. We should be treating everybody the same at work. We shouldn't be labelling or sectioning anybody off because of either their beliefs or how they feel. So in terms of issues then, there's often significant issues and offence taken when referring to gender. So in terms of the word woman that I'm going to use as an example here, there's the inference that only biological women can be classed as having the gender woman, which when we're talking about this issue is incorrect, essentially. Now, where the confusion often comes from is where we're confusing gender identity, which is on the top here, the green, versus, and perhaps gender expression, versus biological sex. So biological sex, if someone is female, they were born with female genitals and they have been allocated the female gender at birth. That gender identity may well change through their life. So someone may be born and classed as a female in biological sex and may then identify as a man as they go through life. That would be their gender identity. So where we get the confusion sometimes is between that gender term and the biological sex term. So this is a really, really useful slide. So the original concept, as it says on the slide, is it's pronounced metrosexual.com. I think someone's already asked if we're going to be giving out a copy of the handouts. So this is something that is going to be circulating, and particularly for someone who's working in employment law and HR, this is a really, really interesting slide that has, Lisa, I agree, it's powerful. There's a lot of information on here in terms of, how somebody is feeling or what it is that they're actually talking about. And this slide, actually, some of the research that I've done, some of the most powerful information comes from websites that are targeted at people who are in sort of their late teens and early 20s, who are perhaps struggling with understanding their feelings. They're struggling with understanding how they place in society and how to describe themselves. So, like I said, I really do like this slide, and I think it can provide quite a lot of insight into what it is that people are talking about and what it is that they mean when they're using specific terms. So taking this slide then, so when somebody identifies as a woman, they do not need to biologically hold that sex, so they wouldn't need to be female intersex or male. If someone identifies as a woman, that is how they are presenting and that is how they would prefer to be referred to. So when we talk about things like gender pronouns, again, this could be someone who identifies as a woman and opts to use the pronouns she or her. So how do we navigate it then? So contentions cause, so it always comes down to toilets, ultimately at work. There's lots of issues around harassment and discrimination policies and the more serious stuff that we're going to come on to, but the big question that we often get is, what do we do with the toilets? So what I'm going to talk about here is the contention that's caused by the decision to allocate facilities based on gender identity rather than biological sex. So coming back onto here, where you've got companies that are using this green scale when they are allocating the use of facilities and not the purple scale. So, for example, if you allocate the use of separate toilets based on gender identity, any person identifying as a particular gender may use the appropriately labelled facility. By contrast, if you go the other way, so if we're going off the purple scale, and I'm not saying either one of these is right, it's just for discussion. If you go off the purple scale, if you allocate according to biological sex, but including those who have undergone gender reassignment, the facility would be limited to the use of those who have that biological sex. So that would be female and male. Now, neither one of those is technically right, and neither one of them is actually that inclusive and is likely to cause issues, because what we're trying to do is going, well, look, you are categorized this way, so we're going to put you in that box, which with employment is always going to be fraught with risk. So how do we navigate it? And again, coming back to the starting point, we should be inclusive. How do we think about, how do we treat staff fairly? How do we treat them equally? And how do we make them feel part of an inclusive environment? We shouldn't be jumping straight to, well, this door's for you, this door is for those people. How do we start at a fair and equal basis? Now, what we often get at this point is people going, but what if I've got vulnerable women who are working for me who have been abused before they came to work in our company? Or what if I've got men who are who are body conscious and they want to ensure that they've got privacy? Well, we're kind of jumping ahead. We're at the starting point at the moment, which is how do we treat people fairly and equally? And we're sort of setting the bones of around how we're going to approach things. The next stage should then be including gender identity and gender expression in anti-harassment and discrimination policies. So as an employer, putting your public-facing face bang up to date, saying, look, we include gender identity and gender expression in all our anti-harassment and discrimination policies. If you treat someone poorly because of the way that they identify or because of the way they express themselves, you are going to be in trouble because we do not tolerate that in this workplace. So around those bones, we're putting a level of insulation and protection for people so that they feel included. Permit gender expression. So whoever decided that men have to wear suits and women must wear skirts, hopefully this is very much a thing of the past. If anyone of either gender or biological sex wishes to present at work wearing a suit and tie, they should be permitted to do so. There is no real reason why someone who is presenting as a woman or someone who identifies as a woman should not be allowed to come to work wearing a full suit. Protect privacy as well. So if someone confides that they are transitioning, or if a recruitment check reveals perhaps that somebody's gender has changed, that should have absolutely no bearing on someone's employment with you, and it should have absolutely no bearing on how they are treated. That should be respected, and their right to privacy should be absolutely respected as well. If you have those who are transitioning, if you've got someone who says that they either have an interest in transitioning or it's something that they are perhaps researching, educate yourself, read guidance, go on training, take advice, understand the process that they're going through, perhaps physically or perhaps just mentally, and have an open door. Don't be afraid of having these discussions. And if someone comes to you and says that they are going through a process, there is absolutely no harm in saying, look, I am inexperienced with this. I'm not particularly educated on the topic. I'd really love to have a discussion with you to understand how you're feeling. Because how someone is feeling has got nothing to do with how they identify. It's got nothing to do with perhaps the process they're necessarily going through. You don't need to understand the nitty-gritty of it to understand how another human being is feeling, because that is what you're dealing with, another human being. Implement training for other staff members if you feel it's appropriate or if it's needed. And the reality is that most workplaces do need this. So understanding about terminology, understanding about how all staff members should be treated in the same way and should be treated in an inclusive and equal manner. And where a pronoun preference is given, enforce it. Do not allow it to be used as a weapon against that employee. So if you have someone who is perhaps biological male, but who is gender identifying as a female, and they ask for the pronoun she or her to be used, do not allow that to be used in a sarcastic way, or for people to do the whole he, oh, sorry, she, and to make a big issue out of it. Yes, people are going to make mistakes, and it does take time to bed in, but it is extremely important that someone's personal preference that perhaps they have taken a long time and a lot of personal thinking to come to is then used as a means of upsetting or distressing them or making them feel like they no longer belong somewhere. So these are very basic steps that we can be taking to make sure that we have an ultimately more inclusive workforce. And the reality is, we should be doing this for all protected characteristics. So if you are employing people who are disabled or people who are from a different culture, or if there is something about someone that perhaps is a bit different or we don't understand, these are really key steps that we should be taking in respect of all people who work for us, not just people who are perhaps wanting to express their gender in a different way. So when we look at the gender route, if we allocate facilities or things like that based on gender, we risk discrimination claims potentially from biological staff members who say that they feel threatened, excluded or harassed. If we go down the biological route, again, there's a discrimination claim for those who are identifying of a certain gender. So what do we do? It seems like no matter which route you take, if you make it that black and white, you are going to be facing the risk of a claim. So gender identity has been classed as a belief that is covered under the Equality Act. Now, crucially, this is not just, so if you have someone who is expressing their gender in a way that is different perhaps to their biological sex, that belief is protected. However, the belief of people who state that biological sex cannot be changed and that they don't believe in gender expression or gender identity, that is also a belief that is protected as well. So you cannot discipline somebody for saying that they believe only someone who is born a biological female can be a woman. However, if someone is presenting that view in an offensive, discriminatory, or in a way to attack somebody, or in a way to make somebody uncomfortable, that element of the behaviour can be dealt with under a disciplinary process. But simply because you know that somebody holds a certain belief, that is not something that you would ever discipline somebody for. People are entitled to their beliefs on these subjects. So what about the bathrooms? Coming back to the bathrooms. So despite all the good work that can be done, as I say, it always comes back to the bathrooms. So where you have businesses that say, we can't possibly have a third bathroom, it's going to cost us far too much money. Despite the fact that it's really common to have disabled bathrooms, baby changing units, it's not massively uncommon for there to be additional facilities to help people who have additional needs or requirements. Now, in mentioning the disabled toilets, one thing that you absolutely need to be aware of is that if you tell someone who is expressing their gender in a way that is different to biological sex, and they're saying, well, I want to use this bathroom, and you've got employees saying, well, I don't want them to use that bathroom, telling them to use the disabled unit is the wrong thing to do, because what you're doing is saying, well, look, actually, you don't belong anywhere, so go in the disabled loos. That is absolutely the wrong approach. Have a step back, have a think about your resources and your budgets, and actually how are you allocating things anyway within the workforce. What I would say is you're never going to please everybody. So there was a case some years ago where there was this very issue being debated, and you had someone who she had actually transitioned from male to being female. And she said that the name woman or ladies or female on the doors was offensive. So when the judge suggested perhaps the little icons, she said those were equally offensive as well. You can't please everybody. Someone is always potentially going to take an issue with everything. However, if you do things in a well-reasoned way, starting at an inclusive and equal point, and you justify what it is that you're doing and why, then it's going to be difficult to criticise you legally. Now, when it comes to bathrooms, I can't actually believe I'm presenting on this. Of all the things I thought I'd be doing when I was at law school, presenting on the law around bathrooms never crossed my mind as one that I would be doing. The law requires that only suitable and sanitary conveniences are required, and that separate rooms containing conveniences are provided for men and women, except where and so far as each convenience is in a separate room, the door of which is capable of being secured from the inside. So, getting that out of lawyer speak and into the real world, essentially, if you have toilet cubicles with full doors that can be locked from the inside, you don't actually have to allocate them as gender specific. So you could have general bathroom facilities that have full door cubicles that anybody can use. Now, the trendy thing to do at the moment is label those as gender neutral toilets. However, before gender neutral was even a term, there were many buildings that either didn't have the space or the resources to allocate male and female units, and actually have always just had one set of bathrooms. So there isn't a requirement by law to provide single-sex facilities if the toilets are essentially a room and not a cubicle. YouGov did a poll on this, and a third of those that were polled stated they would prefer a mixture of sex-specific and unisex facilities. So if you do want to go down the route of really making sure that everybody is accommodated for, you could have sex-specific units and then a unisex or gender-neutral facility as well. Now, if this isn't an issue in your workplace, you don't need to make it an issue. However, what I would say is, even though some of the latest figures that have come out of, I think it was Stonewall, said that the gender identity issue affects about 4% of the population, they do reckon that that number is low because there's still a lot of people who aren't confident talking about this sort of thing, or confident saying, well, actually, this is something that affects me. So what I would say is, if you're not going to make any changes to facilities, and I'm not saying that you have to, is have a plan. So if this does become a bit of a problem, and by problem what I mean is that you've got to make a decision or perhaps find some money for some new facilities or look at how you allocate things, is that you've got a bit of a plan for what you're going to do, or for how you're going to address it. So whatever you decide to do, ensure it's reasoned and justifiable. If you're working in an environment where you're working with vulnerable people and you are worried about people from an opposite biological sex mixing perhaps with vulnerable people, that is very much something that you should be taking advice on. It is a complex issue. I'm sure, if you've been reading the press, that you'll have seen that there have been, I think it's 2 cases in the UK, where there is a biological male who identifies as a female who has been placed in a woman's prison who subsequently went on to rape female inmates. So it is very topical. It's something that even government organisations are struggling with in terms of who do we risk offending versus the welfare of certain staff members or service users. There is a balancing exercise that needs to be done. So when you are undertaking that balancing exercise and when you're taking legal advice on it, ultimately your defence is going to rest on whether you have a proportionate means of achieving a legitimate aim. So that is our defence in respect of things like indirect discrimination. It's a very complex issue. So if you are in an environment where you are dealing with vulnerable people, or you are dealing with people who've got a certain background that puts them perhaps more at risk, then please do make sure that you take advice on this issue before you make any irreversible decisions. So I got a question there from Pamela. Would you label the bathroom gender neutral or no icon? You could, it's gender neutral is generally seen as an inoffensive term. So you could put it on there, or you could just say universal bathroom. Anybody can use the bathroom if they feel comfortable using it. Or indeed no icon, just flag that it is a bathroom, as Lisa's just said as well. So just call it a bathroom. Training as well. So do shop around if you're going to do some training on the issue. Traditional training providers haven't quite caught up yet. There are some very good courses out there, and there are some really good training providers out there, and it can help with things like the use of language and sensitivity and understanding the issue. Now, I'm not going to name this training provider where I've got these screenshots. I did have a look at the provider that our firm uses for virtual training for new staff members and things like that. And this is all they had on gender reassignment, transitioning and beliefs. So it was an example of what a transgender employee might request. So in terms of things like pronouns or adjustments at work, and a learning point. That is not enough. It's not good enough, frankly, in this day and age. I do think the training needs to be more in-depth so that people understand the issue, they understand what people are going through, and they have more confidence to talk about something in an inclusive and equal way. So that's it. We've done it just under the hour, so we've managed to not go over. I did think we were going to run over today, so we've managed to crack on through it. Happy to take any questions. I haven't seen any pop up in this session, so normally I was also trying to multitask and spot them as they come up, so I don't know if anything's come into you, Kath. I hope you've all enjoyed the session. I hope you've all learned something. And as I say, I hope I haven't offended anybody either. And if I have, I do apologise. But thank you again, Kath and the team of JVP, for having us on. We do enjoy these sessions, and we love working with you guys.
Well, Alyssa, from my view, that was certainly very great advice, obviously navigating around, particularly around navigating around gender identity in the workplace, and so sensitively and respectfully delivered as well. So hats off to you for that, especially being such a challenging area. One question, I guess, just to throw at you there in around that topic. Is there any change likely to happen around, for example, if you had a female security guard required that had to conduct searches, and where a business maybe had both female and male? Is there any likely to be any impact on things like that, or in the care sector again, where you've got a sort of exceptions really to the rule?
So we do see this a lot in the care sector, where perhaps you have elderly women, particularly women of a certain faith, who will only agree to be cared for by people of the same biological sex. Sorry, slipped the tongue there. So where you allocate a specific role based on biological sex, that is something that you would, if a claim were brought, you would defend as a proportionate means of achieving a legitimate aim. So you wouldn't be saying necessarily, well, look, we've got a service user or a requirement that requires us to discriminate. However, we have an identifiable and valid need because of perhaps someone else's beliefs. So taking the care example, that requires us to allocate someone of a certain biological sex. Now, those sorts of things have been challenged. I'm not saying that there is a really easy way out of that, but ultimately you will be defending that on the basis of it's a proportionate means of achieving our legitimate business aim. So same with security guard, police, sort of same biological sex searches, things like that. We'd be saying it's a proportionate means of achieving a legitimate aim.
Okay, that's great. Thanks, Liz. I've had a few queries come up from employers recently around that sort of area, so that's hopefully been of use to some are listening today. And you mentioned earlier, really, well, on the more of the topic around sort of cost rising, we're talking about national insurance increases, and one thing to sort of share with you all listening today is obviously Alyssa was sort of talking about sort of the increase of costs for businesses, and obviously potentially more requests coming through, things like flexible working and salary increase requests. One thing I will say from a recruitment point of view, if you're trying to attract talent, is we're certainly seeing with all the employees that we work with across the UK, many of them now are reviewing their salaries, looking at the packages that they're offering. So if you, in this very tough recruitment market to attract talent, if you want to attract the best people, it is a really important time to be reviewing what you are offering. Otherwise, you may find that actually you are no longer competitive compared to other employees in the area or in your industry. So it's obviously very important for retention with regards to existing employees to deal with those requests and maybe proactively look at these areas, but also it's the impact that can have on recruitment as well. So I don't think I've seen any other questions coming through, but I'm sure if anybody just wants to speak with Alyssa one-to-one, I'm sure she'd be happily obliged. And certainly from myself, with regards to any recruitment or talent attraction questions that you may have, if you want to speak to me, give us a shout. Contact details will come up on the screen now. And that just leaves me to say very promptly at 11 o'clock, thank you very much, Alyssa. Really appreciate how busy you are at the moment. Well, always are, but especially at the moment. So thank you for taking the time to share that really useful information over the last hour. I'm sure, like everybody else, I certainly appreciate the time that you've taken today and delivered so eloquently too. So thank you very much. Hope to see you all again soon at another session, and have a great rest of the